Hi, good afternoon. Can you hear me? Hi. Good afternoon, everyone. There you go. Good afternoon. We'll do this. So the name of the presentation is going to be like Understanding Trust, What They Can and Cannot Do. And I thought I always do the beginning of our trust presentations with clients to kind of understand what exactly it is and kind of get a baseline for why you want it, why you don't want it, who the parties are, because it can get really, really confusing if you start from the fact of thinking about like, well, trustee, executor, all these names, you start to lose what you're doing, right? Because that's not really the block and tackle. The other side of that we'll go over today, so we'll identify the parties, how it works, but we're gonna do it real generally so that you can understand like what this might mean to you. And then it's not lost on me that this is all fiction. I mean, this is made up. Let's not mince words about it, right? This is a legal fiction that was created to keep you out of probate and to provide tax advantages and to provide a way of transferring assets on triggering events and a way to provide for people. But it's all paper, case law, and statutes. Over time, people made up this theory on trust and why it works the way it does. I'm going to demystify that for you so that it becomes crystal clear. So the thing I tell everyone that comes in for an appointment is this. Throughout human history, you can imagine a time when if you possess something, you owned it. I'm holding this, it has to be mine because I'm holding it. Over time, the law started to recognize this theory where I say, I'm giving my sword to Arcely and I'm leaving the country. And if I don't return, give it to Mike. Arcely's holding the sword, but it's not hers. And the law won't ever see it to be hers. She's holding it in trust for me with instructions. And that's the whole theory. One holding property for the benefit of another. That's it. The reason why we put it in writing is because of the statute of frauds, which says that we don't respect oral agreements upon death. That's just a statute of frauds, right? So what we do when we do trust planning is we write a trust agreement. One's going to hold property of another for the benefit of another. So, that's backwards. I start at the end. Oh, we'll go back to it. Okay, so there's three parties. The three parties, have you guys heard of this one? Trustor, settlor, grantor. This is the person giving the property to the trust. In my example, that was me. The second party is the trustee. That was Arcely. This is the worst job in the world. This job is awful. This means you have to do all the work and you don't get any of the benefit. So I always tell people, in a funny way, if you have 4 kids and one of them really wants to be a trustee, that's the one you don't want to be the trustee. Because they're going to do something awful. And last, you have the beneficiary. That's the best job in the world. You get all the benefit and you don't have to do anything. So that's a fabulous job. You can. We all aspire to be beneficiaries one day. In a living trust, you guys ever heard of living or revocable trusts? And if this is too basic, I'll skip ahead. But in a living trust or revocable trust, these three parties are the same person. And the agreement literally, now this is not lost on me how crazy this is. The agreement literally says, I, David, give this property to David for the benefit of David. I give the property to myself for the benefit of myself. I mean, that's goofy. Let's call it what it is. But the thought process of that is this. In the agreement, the magic happens when I die. Because when I die, it says, well, now David's not going to be the one managing it. And David's not the beneficiary, and here are your instructions. So by creating the trust during life and doing that goofy thing where I have an agreement saying I'm giving it to myself for my own benefit, when I die, it'll tell me who's going to be in charge and who's going to get it. In charge, recipient. Okay? Any questions about that? Not really, okay. So let's go into the first party. The trustor, the settlor, the grantor. In some of our trust software, they even call them a trust maker. I really hope that catches on because it really speaks to what they're doing. They're making the trust. They're giving the property. So they have a few decisions when they make the trust. The first one, do I want it to be revocable or do I want it to be irrevocable? If they give it irrevocably, it's no longer theirs. They can't do anything with it anymore. And they are not allowed to be the trustee if it's irrevocable. So that's used in a number of situations where A, either you want to make a present gift but you don't want it to go right now. B, you're trying to protect something from creditors. Or if you're trying to qualify, sometimes people trying to qualify for different government benefits use irrevocable trusts to do that because all of a sudden all that property is no longer yours. So you're not adding that to your statements. There's tax considerations on whether or not you want to have your property in trust and how you want it set up. I usually refer you back to your accountant for that. I can give you a basic idea of it, but that's more appropriate for a professional in that area. But some of the tax considerations might be just generally the estate tax, right? Currently, it's extremely high, and we don't have a state estate tax. So there's a lot of people, maybe you're one of them, that got a revocable trust in the 90s, and the estate tax was really low. And you got what's called an AB trust, which means when you die, we're going to break your trust into two trusts. And one of the trusts is going to preserve the estate tax exemption for the deceased party, and the other trust will be a living trust for the spouse that survives, and that will have their estate tax exemption in it. A, B. That made a lot of sense to people when you could only give $1 million when you died to someone without the 40% tax. But now you're allowed to give someone $13 million without any tax. All these people have trusts that are pretty much a tremendous expense to administer. When the first person dies, pain in the neck for the rest of the surviving spouse's life. And what they usually do is they just ignore it and just keep going on down the road, which causes problems downstream with people that are entitled as beneficiaries of one of those trusts. So that's just some of the tax considerations. And the last thing, and this one is always of great interest to people, how do I want the gifts to go to people? Do I want them to go outright? 90% of the people, we write 6 trusts a week. 90% of the people say, when I'm gone, just give it to them outright. Or do you want to leave your gifts in trust, which is the same concept we just talked about. The trust creates a trust, so the trust is the trustor. You name a trustee, and the beneficiary now gets the money or the gifts in accordance with that trust you left it in them to. So that could be done for special needs. It could be done for underage beneficiaries, and we generally provide for that. And then it's always done for that kid that you're just like, I don't know. You can't give them $10, it's gone, that kid. They sometimes get their stuff in trust. But last thing I was going to say that's interesting is, and this is the most uncomfortable thing that I talk about, is whether or not you're going to leave it in trust to your spouse, or if they're going to get a chance to amend or revoke the trust when the first dies. Why is that important? Somebody tell me.
My wife hates me.
Yeah? Anyone else?
If you each have your own set of kids.
Your own set of kids? Right. Good. And so, also, because revocable trusts provide no asset protection from creditors, sometimes an irrevocable trust, if it's a large estate, is preferred because, gosh forbid, she hits someone with the car after husband's dead, that money's not reachable. So, but the real reason why they do it, and I'm not choosing sides, but it's usually the men that remarries someone younger who already has new kids and then starts to realize, my kids are doing great. I'm going to amend the trust and we're going to give a lot to her kids. And the deceased wife starts turning over in her grave. Trustee, worst job in the world? Worst job in the, I put United States, but I think it's the world, but I don't know a lot about foreign countries, so we'll just say it's the worst job in the United States being a trustee. Here's what you can expect if you're a trustee. Everyone thinks you do a bad job, you never account enough, they question what you do, there's no transparency. I mean, that's the life of a trustee. Yes?
Or you can hire someone out to do it, a third party, so that...
Yes, you can, but it's getting slimmer and slimmer. It's getting harder and harder to find them.
There's fiduciaries.
They're out there. I know that most of the banks have got out of the business of doing it. You used to be able to name a bank their trustee services, but they're very particular these days on who they'll take. And this is something just to remember when you're picking your trustee, because a lot of people want a lot of strings attached to their gifts. The more control, the heavier the burden. The more control, the heavier the burden. So if you tell your oldest child that he can give all of Sarah's gift outright, but when it comes to Jeremy, you're going to keep it in trust. And if Jeremy loses his job, you're not going to give him distributions. And if Jeremy wrecks that car, you're not going to buy another one. But when Jeremy does get another job, you can start the distributions again. And if Jeremy actually goes to school, you can give him 50% of the principal when he graduates. Sounds great, except what are you doing to your oldest child? They're now having to deal with all of that. And so just keep that in mind. The more burden you put on this trustee, it's not an easy thing. I mean, frankly, let's say I'm Jeremy's dad. I've never been able to control Jeremy. Now you're expecting his older sibling to be able to control him? So, something to consider. Last is the beneficiaries. The best job in the world. And all I wrote up here was, what's the goal? And are you helping them or hurting them? So, when I say that, all I'm saying is your conditions or your hopes or your goals for them what they really want? Or are you going to put them in a position where they have to live a life they don't want to live because of the financial gain of it? So you have to be careful with how you structure gifts to beneficiaries. Everybody pretty much on the same page here. Any gift you receive is separate property, right? It's not community property. So if one person's parents die and they get that gift, that's separate property. It's not subject to division and divorce. Until, what? They commingle it. They use it to put a deck on the community property house. They use it to start a business with their spouse. And then it starts to lose its character. So I understand you may have that daughter that married that terrible son-in-law. And you hate him. And you want to leave this in trust and give her payments so that he can never get his grimy hands on her inheritance. I get it. But remember the stress you're going to now be putting on her. If she is in an emotionally abusive relationship or something's going wrong, it's not going to stop because you put the money over here. Right? And so it's just something else to consider. You know? Here's some common areas of concern, and then I'll take questions. This is just stuff I'm seeing, okay? 1, is your trust funded? This is the biggest no-no. This is the one we see all the time. It's good for me when you do this, but it's not good for you. So a trust is a basket. And anything you put in the basket, the trust can deal with when you die. How do you put something in the trust basket? You title the asset in the name of the trust. Let's just demystify that. The deed to this house has to say Jones Family Trust. Nobody cares what's on your schedule. Your schedule says, oh, it's in my trust. The schedule says, 1, 2, 3, 4 rain shadows in the trust. Nobody cares. The deed has to be in the name of the trust for the trust to operate. Otherwise, it's going to probate. Okay? So, we see that all the time. Is property not in the name of the trust? They go, wait, they had a trust. And then we have to tell them we don't care and go to probate and beg the court to put it into the trust because it was a mistake. And that petition is called a Hegstead petition. And it costs $6,000 to do. So it's triple what it costs to do your trust. So don't be that person that has this beautiful trust that's not funded. Everything has to go in. The second thing I want you guys to think about, because this becomes an issue later in life, is are you happy with your trustee? That's the person who's going to take over if you become incapacitated or on the second of a married couple to die. Are you still happy with that person? Okay, because especially when you become incapacitated, right? Is that the person you want making the decisions? Are they still in a position of authority with their siblings? In a perfect world, we would all know this super young, intelligent, wonderful, generous guy or girl who doesn't even take a dollar for themselves, and that's who's going to be your trustee. And they're not related to you, right? But who has one of those? So most times it's a child that you name the trustee. Is that still the child that you think should be the trustee? And finally, are your beneficiaries updated? Is the gift still going where you want it to go and in the same amount? And this is where people take on certain charitable considerations. They take on ideas about, well, Susan, she's always lived in the house, and now I'm going to make it sold and divided 3 ways. Do I still want to do that? So that's something to keep in mind. Is it still the way who you want it to go to?